All right, I have 12:01, so we're going to get started. Thank you very much for joining us. This is the California Lawyers Association webinar focused on the CCPA enforcement trends. We want to share with you a little bit about the California Lawyers Association. If you're a member, thank you for joining us. If you're not a member and you would like to join and get more information about CLA, information about how to join the section is at the end of this slide deck, which will be available, as well as a recording of this event on our events page. If you go to cla.org/privacy, I believe is the link. CLA is, I think, one of the world's largest bar association representing all California licensed attorneys. And so the privacy law section really is representing all of the privacy lawyers who are licensed in California. And so we welcome you if you are one of our members, but it is also open to non-licensed California, or rather non-California licensed attorneys, and also non-lawyers as well. So we have been doing a number of webinars and these fireside chats with talking about the CCPA and the CPRA. So past events and CLA events are available again on the events webpage if you go to CLA privacy law section. Today's session is not a CLE. It is really meant to be a conversation. And we're really excited to have the four partners that are going to be joining me, and I'm going to be passing on to Lothar as the moderator for today's session. Just wanting to let you know that this event is being recorded, and your question and answer is the function that we have available if you would like to ask any questions to this group. I believe the chat is disabled, but we would like to make this as interactive as possible. With that, Lothar, please take it away.
Thank you so much, Jivon, for putting this together and for me to be invited to be the moderator today. Very excited about this update that we want to give. And we have a little slide deck just for visuals in the background, which I will show here to introduce the esteemed panelists who are joining us today. And we have, for that, experienced practitioners who deal with CCPA enforcement of other privacy laws, who are very familiar with the trends and details of such actions, and we'll share a lot of helpful practical information, brand new from practice. Alysa Hutnik, partner and chair, privacy information security at Kelley, Drye & Warren. Dominic Shelton Leipzig, leader in global data innovation at tech privacy at Meyer Brown. There's David Zatoni, shareholder, data privacy, cybersecurity practice at Greenberg Traurig, and then Jivon Serrato, partner at Baker Hostetler. And I apologize in advance if I gave all your name German pronunciations here. I can't help myself in that. We have as an agenda prepared our introductions, which we just started. We want to talk a little bit about some trends and statistics that we've been seeing, and then dive into how inquiries from the California Attorney General proceed, what the authority is interested in particularly, and how they act vis-a-vis companies. Talk a bit about possible outcomes for motivation, and then dive into the substantive focus, the types of topics, the question demands that come up, and cover a couple of other points here, details in terms of what we're seeing, binary violations, traffic ticket enforcement versus more complex arguments being advanced, and what other California privacy laws are being enforced at the same time. So I'll start with some high-level trends here that I got from our panel. We had some prep calls and email exchanges to just share from all of us what we've seen in terms of the companies that are being affected and what is on a high level happening. As you know, the California Consumer Privacy Act has been amended by the California Privacy Rights Act. Those are two separate laws, but really the one that everybody has to comply with is the California Consumer Privacy Act, CCPA. We'll be referring to that throughout the presentation as CCPA, but we will mean in the form of CPRA. Some provisions already took effect in December 2020. Most of them will take effect on January 1, 2023, but with a one-year look back. And that's what we'll be referring to when we talk about CCPA specifically. So what everyone was expecting is that the California Attorney General is going to focus on ad tech, online digital advertisement, and that is also happening. This was a very big point of the campaign of the two ballot initiatives in 2018, 2020, and we do see particular interest in that. That's just something that can be done during pandemic, also from home. Basically go through a website, see what cookies they put, what kind of disclosures they have on the website, and we're seeing that. But all of the panelists here today and have seen also enforcement in other industries, financial institutions, medical devices, retail. It has not been limited to the big online advertising giants or the smaller ecosystem that has developed there. We've also wondered about the geographic reach of CCPA. We have been expecting that there's enough to do in California for a while with so many companies doing business here. We're the 5th largest economy in the world. Pretty much all companies that do business online have something here, but there's also a lot of companies that are headquartered here. And when we took a poll, all of the panelists have seen actions that are directed to companies who are not headquartered here and who may even be doing business relatively tangentially in California. So this continues to be a topic that California will influence data privacy law developments worldwide. In terms of how the investigations conduct and problem surface, we are aware of many that will be based on individual complaints by consumers, by consumer advocates flagging things. But we also see that the California Attorney General does their own investigation. Their staff goes out both offline and online and takes a look at things. That's markedly different from what we've seen in Europe, for example, after GDPR enforcement, where the authorities were so overwhelmed with complaints and under the GDPR have to respond to every single complaint that many of them have not been able to do anything that wasn't triggered by a complaint. And even where there is a complaint, it takes some years to get back. The California Attorney General's office is not so tight. They don't have to respond to everything. So they have been following up on some complaints, but they also have been looking at things in their own initiative. Those were really the high level that I take here from my notes. And with that, I think we could already proceed what the stats are concerned to our next topic, where we want to talk about some of the, to always go back to presentation mode here and clicking very fast, talk about how the inquiry proceeds. And I think on this one, I'm going to start with Jiwon to walk us through how a typical inquiry comes to a company's attention, how it proceeds, and I will also get some examples from other of the panelists here. Of course, none of you are speaking on behalf of any particular clients. You're not sharing particular specific individual proceedings. All of you have several things working. It's more of a question of sharing in general how the office acts and what is the first thing that a company knows that they're being investigated.
Sure. So one of the first ways that a company may know that it is being investigated is to receive a notice of violation from the California Attorney General's office. It will have a heading of notice of violation. It'll be clearly marked most of the time, and it will have a list of issues that the California AG is alleging is a non-compliance issue for that company.
Now, do these things come in the mail or by email, or are they submitted through customer reports? How do they usually come to companies?
I think it can be both by email or by mail. Usually we receive it when the client forwards it to us, usually by email.
And then followed by immediate press attention or confidential for a while at least?
Yeah, really, really good question. So this was actually a question that was answered in one of our previous webinars. So I'm going to paraphrase what one of the Deputy Attorney Generals have answered this question in the previous webinars that CLA has hosted. All of the investigations for CCPA are confidential until they become public, until the California AG decides to move forward on the enforcement. So, we should note that I think everyone on this panel, we are all actively working with companies in remediating and responding to the allegations of non-compliance. All of them are confidential at the moment, and they do not become public until we have a settlement.
So I'll move on to Alysa to also share. When we get this letter, we have a notice of violation. Does this come immediately with requests to produce documents like an inquiry from the Federal Trade Commission, or are these more informal inquiries about particular topics?
Maybe a little bit of both. So the notice of violation letters usually come along with both information requests and document requests. I think if I compare them to an FTC CID or an access letter, they're not as long and perhaps not as complicated, but certainly some of the requests have been fairly time intensive for my clients. But I would say working with the AG's office, they've been fairly reasonable in coming up with modified timelines or scaling the request if there's a reasonable alternative to be able to be responsive.
To stick on the question of document production, so it's not as formal as what you see sometimes from the FTC, but you've seen even in initial letters, requests for documents. We'll cover the subject and the topics a little later throughout our presentation, but just from a process perspective, what kind of documents are being requested? What have you seen that companies have to pull together?
So it depends on the subject matter of the investigation, certainly. So if it's, for example, of notice of financial incentive, then asking for documents and disclosures relevant to that notice of financial incentive. And I think we've certainly polled the peers on this call and other calls, and it varies, even with the same subject matter, what the particular request may be. But you can assume that based on the subject matter, they're not going to just take your word for it, and that you're going to have to demonstrate exactly how the company is complying with the relevant legal provisions.
Now, this term, demonstrate how to comply, documentation obligation, familiar to those of us who've been working on GDPR inquiries in the past, and something that is a good reminder from a compliance and proactive prevention perspective to produce documents and have them ready to go. I'll move on to Dominique and ask, what is the next step? The client has this letter, they give you a call, hopefully within temporal proximity to receipt of the letter and without already halfway answering, but what is your recommendation for the next step for the client process-wise, what they should be doing next?
Yeah, so, I'll say just very quickly that sometimes by the time it gets to outside counsel, it might have bounced around the company for a few days, and you have 30-day cure period. So, outside counsel might actually, by the time a letter goes to the CEO of the company, it gets filtered down to the general counsel figures out who in the company is responsible for CCPA. This chief privacy officer gets found and it bounces out to you. So the first thing I'm thinking about is timing and where are we to understand the facts, because there is mindful, and the client needs to be mindful. They may not be aware right away that the 30-day cure period is upon us usually. And so want to make sure if there's something that can be cured, then it's cured within 30 days, because then it's as if no violation occurred at all. So that's the first thing I'm thinking about.
No, a very important point here. So this 30-day cure period is in the current statute. It will largely go away at the end of the year from a legislative perspective. So the Attorney General wouldn't have to allow curing anymore. I don't know, Dominic, you've been doing work for clients in confronting authorities, particularly the California Attorney General too. I think in the past, even where there wasn't a specific cure period, they've been pretty good about working with companies. And if things could be resolved, even if there wasn't a express, it never happened kind of situation, then we've seen relatively few fines that would be imposed without at least trying to resolve it first. Is that your sense too?
Yes, there's definitely going to be an opportunity if you wanted to have that discussion and you want to get all the facts in order so that you can have a cogent discussion about what it is you are doing. And maybe there's some confusion. I will clarify that the extensions I've seen with respect to CCPA, and you're right, it's all going to be moot pretty soon because you've got the agency and no more 30-day cure period. But the extensions that I have seen have been towards the written response. But in terms of extending the time period for cure, I have not seen that happening. So, so in terms of just thinking about, thinking about public companies and what Alysa was talking about depending on the issue, whether it's ad tech that just moved our markets by 1.3 trillion in March, or whether we're talking about something else. I'm thinking about all of these things and the timing of moving quickly.
Now, super helpful. So number one, focus. If you see something in the letter that has to be cured, let's see if we can cure it. What is on the way and start that. Now, David, while you're curing internally, you're also thinking about how to respond to the Attorney General's office. And what is your recommendation from a practical perspective there? Is it an email back, we're on it, or you're trying to schedule a call, meet with them? What's your recommendation in terms of how next step? And are you going to be in the meeting, or is this something clients want to time themselves and maybe with support from you in the background? What are the range of options here and your recommendations to consider?
It's a great question, Lothar. So, and to give a little bit of perspective, I've probably been involved in about a half dozen investigations, but to your point, not all of them have I made an appearance. And so when clients are thinking about how to respond, one of the strategic decisions is, should they respond directly to the Attorney General's office? Should they respond by trying to have a preliminary telephone conference to clarify issues, particularly if there's some ambiguity or if there's document requests or interrogatory requests that are maybe overbroad? Or should it be outside counsel? And I've handled these in all different ways, where sometimes it is the client who is really the face to the Attorney General. Sometimes it's us who's the face to the Attorney General. I think a lot of it depends on context, culture of the company, and what the alleged violation is. So the Attorney General's office has done a number of sweeps. Sometimes when they're doing a sweep and they're sending out violations maybe to a dozen companies or 24 companies or a large number of companies, and if there's a fairly quick response that can hopefully dissuade them that a particular company is a target, maybe something they didn't see on a website or didn't see in a store, sometimes it is a little easier for the company to directly reach out to the Attorney General's office and try to address the issue head on. You know, typically, if it's something more complex, something where there's a lot of requests being made or a lot of violations, the first step usually is to try to pick up the telephone and have an introductory call, kind of talk through, make an introduction, open that line of communication, because there's going to need to be that back and forth, both from outside counsel, but then potentially the client, but also from the Attorney General's office on things like Dominique was saying, timelines for the response. Oftentimes, if the right people in the company got the request a week or 2 weeks before it's due, and a lot of information, a lot of documents are being requested, you want to make sure the Attorney General's office know that it's gone to the right person, that it's being handled correctly, but then also work with them in terms of what can you get them immediately and what's going to take a little bit more time.
Thank you so much, David. So these are initial process considerations. Now follows a longer back and forth on individual topics, and we will dive into substantive points that are of particular interest and that companies should be preparing for. Before we do that, let's talk about possible outcomes. And for that, we have prepared, just as a little visual background, the ultimate motivator, namely the possibility of fines. In the outcome section here is the verbiage of this administrative enforcement. None of us have seen this happen yet. There's nothing public. Things are on the way, which is a faction of the rulemaking process. I think the California Attorney General's office was extremely thoughtful, as also mandated by the legislation. There had to be hearings conducted. They were starting in San Francisco. I went to that one when it first, the legislation came about. And so the rulemaking was a long process. It had to be certified. It wasn't ready by the time that enforcement could have started otherwise in July 2020. So there were some delays. Now we've got several new legislative pieces in 2020 and a whole new ballot initiative. So there's some delays here, obviously, and we haven't had a fine yet. And my sense is that in the past, the California Attorney General wasn't so focused on heads on sticks or fines, but rather than to drive change and get companies into compliance. But as this investigation proceeds, we want to also see what could be at the outcome. And I'll go around in the same order again, starting with Jivon. What do we get at the end if we addressed everything? Do we get a gold star and a letter, you are a fine company, all resolved, you're in good shape? Or what is the happy outcome for a company once you've addressed concerns?
I would say the happy outcome that we've had with clients is where the California AG says no more questions. So the California AG will reserve the right to bring additional investigations if the facts change. So if there is a
I'm losing Jivon, and I'm going to move on to Alysa. I think Jivon would have said that the happy outcome is that no more questions at this time. So Alysa, what is the unhappy outcome? We've given some answers. We haven't agreed anything, just process-wise. What will the next word be if we said, this is our position, this is much we can do at this point, or we just haven't responded in a while? What comes next then?
Well, there's the hypothetical worst outcome, I would say, from a client perspective is you can't reach agreement and the California Attorney General's office decides to get more aggressive and the matter gets litigated. We have not yet seen that. I guess short of that, they could also decide that they're going to give a draft complaint for a formal settlement, complaint and settlement. I've not seen one of those. All of the examples that I've seen, we've been able to work through in good faith with the AG's office. And while there haven't been any fines, I will say some of the changes that the AG's office determined were necessary are still very costly to the company. So you may not have fines, but there may be significant resource investment that without a whole lot of discretion in terms of the implementation that may need to be required. And certainly some people within that company will not be thrilled with that result.
Thank you so much, Alysa. So we heard the happy news from Jivon. Alysa, the possibility of getting a settlement proposal. Now, between that and actual litigation would be a escalation here in terms of a fine. And I'll ask David in a minute how the fine comes about, whether this is something the California Attorney General just hands out like a traffic ticket, or whether this comes in litigation. But before I get to that technical point, I wanted to see if Dominique had experiences of discussing the options for settlement or talking this through at the beginning with the client, and what your sense is of settlement versus opposing in general, and how those discussions go with your clients.
Yeah, I mean, once you have entered into negotiations with the AG's office and just even outside of CCPA, I dropped into the chat for Cameron a sample final stipulation and judgment that is on the AG's website right now in a privacy matter for just a long time ago, just unfair competition. But basically, then you're negotiating about all of the things that Jiwon and David and Alysa and you talked about. What is the client's overall privacy program? What have they done to mitigate, et cetera? And then trying to just discuss how to get to a number, and it's a negotiation, really, and then a format, and similar to what you've seen maybe in the FTC context or otherwise, there's a complaint and then a settlement that gets filed. And so, look, these things are public. They sit on the AG's website. They're searchable. It's not great for the brand either. So all of the things that Jiwon, Alysa, and David are talking about, if it can be done ahead of time to avoid what you're talking about, Lothar, all the better.
Well, thanks so much. Now we have some great questions in the audience Q&A section, and I'll read those in a second and ask the panelists about this. But before that, David, the key question here that I asked before, and you kindly agreed to look that up and form an opinion on it. Like, let's say we say no to the settlement. We haven't fixed it. And what comes next? Can the authority just send us the fine? And if we don't appeal it within 30 days, we have to pay it. That would be the case in Europe. Or does the California Attorney General have to go to court? And if so, have they done that? And how does that work?
So, Lothar, the statute is pretty clear. The California General doesn't have fining authority. They can't just issue their own fine and then expect you to pay it. In order to take that next step, what Dominique is describing, if settlement discussions fail, the Attorney General's office would have to file a complaint. You'd have to go to court and ultimately ask a judge to find in their favor that a violation occurred, and if a violation occurred, to award a civil penalty. And again, what I'd say is we have no precedent of this. Obviously, this hasn't happened yet in the CCPA context. We do have precedent in a variety of other contexts. And ultimately, we focus on the civil penalty, but the amount of the penalty is not going to be decided by the Attorney General's office. It's going to be decided by a judge. And that judge has factors developed in common law in terms of how they look to different penalties and which variables they look to. I suspect we're going to see California judges follow that precedent in other contexts and look at those same variables. That's very different than I think people who are listening to this who practice in Europe or practice before supervisory authorities, may be very different from what they're used to. I can talk a little more about that. But I think it's also different from what we are going to see in a year with the agency. And the agency's process is going to be different than the California AG's process in that they don't necessarily have to take their first step into court in order to get an initial number.
I think it's going to be a different dynamic, right? If you have to go to court, you have to really make a conscious decision how much resources you want to tie up to fight one particular company. That has to be worth it. But if you are the authority and you can just issue tickets and see what sticks and who wants to fight back, that will be a different dimension. So that's just an outlook here. Let's look at what we have in the Q&A section. One question is, do we have a sense what percentage of inquiries are handled in-house versus handed over to outside counsel? We already heard there is a variety of what handing over means. Like, many of us get questions on it, but we're not appearing in front of the Attorney General's office necessarily, and the cases are different. I don't know if any of you want to venture a percentage.
I'll start and say probably the only one who could venture a percentage is the California Attorney General's office. I think each one of us has a little snapshot. We've got these ad hoc cases, but among my own clients, I've had situations where the chief privacy officer has been the face of the company, and we've been advising behind the scenes. We've had situations where in-house counsel, associate general counsel or the general counsel has been the face of the company. We've been advising behind the scenes. We've had situations also where local counsel, it's a little strange, but where we would have, we are supervising or directing against attacks coming from 10 or 15 different supervisory authorities in Europe or the United States. And this is one aspect under the CCPA, maybe a little unique, but where we might be directing a larger strategy, but we're not necessarily front and center in front of any of the supervisory authorities, including the AG. And then we've had situations where outside counsel would be the primary face. But in terms of actual percentages, that's something I think probably only the agency could really give a good sense of.
I want to ask one more question now, and the other ones we'll actually address as part of our next round where we go into substantive topics. Alysa, you answered this already in the chat room, but it was such a good question that I wondered if you could just elaborate on a little bit for all of us. What are the kind of expensive topics that are coming? Is your sense these are not really required by the CCPA, what we're doing them anyhow to settle, or are they things where at least the California Attorney General think this is hardcore required and you're just remedying something?
So most of my experience has been the California Attorney General's office believes the company needs to comply with the law, and there may be a dispute about an interpretation of a certain requirement. And so part of that resolution may mean making some changes to business practices to address a different interpretation of the CCPA than the company may have started with. And so that requires business changes. I have not seen, and I have not heard from peers, the California AG's office requiring what lawyers would call fencing in relief, something that goes over and above what the law requires. It has been really squarely targeted as to how do you comply with certain provisions of the CCPA and what infrastructure is required to meet those obligations.
Just a show of hands, if any of the other panelists have heard something different, I have not. I mean, some were previously a little bit debating whether it's, for example, the recognition of global privacy signals is something that actually the statute requires. But I don't know if any of you have seen things that were demanded and are not really based on the law at all. If not, then we'll turn to the next topic. But
before we do
please?
that, I just wanted to chime in quickly on the enforcement action and the potential fines. Just wanting to add my 2 cents that our understanding is that the civil action, if the investigations were to move forward to settlement phase, that the civil action would be brought by the Attorney General, and the Attorney General, is our understanding, would be working with the company, the target company, in looking at the fine amount and also injunctive relief. So I just wanted to say that the Attorney General will have a very big say in terms of figuring out both the monetary fine and the injunctions.
The big question there being, what is a violation? In terms of, is that like one time doing something wrong, or is this one time doing something wrong times 7,500? Dominique had something to add on this too, please.
Just on the issue of GPC that you mentioned, I have seen that come up.
And David?
I was just going to make a little distinction between kind of clear-cut violation on the one hand, and the issue Alysa was talking about, the fencing in relief. So I have not seen any type of request for fencing in relief, which would be, for those who aren't familiar with practicing before other agencies, sometimes they go beyond what the law requires. And they say, look, we think you did something that was a bad act, and therefore what we're going to do is kind of create this demilitarized zone in sorts. You can't do practices that even approach the legal requirement. I don't think, I haven't heard of the AG going in that direction. But I would like to just kind of distinguish, that doesn't necessarily mean that they've only been going after clear-cut violations of law. So things like GPC, what Dominique was referencing, but there's other areas as well. I think they have been going into areas where reasonable people can disagree about what the law means. There's no judicial direction at this point in terms of an actual explanation of how the law should be interpreted. And where they might think it's clear-cut, that doesn't necessarily mean that the company or that the industry or that the privacy sector, right? Privacy attorneys think it's clear-cut. So I would just kind of throw that out there as a small distinction.
Yes, we actually had this as a separate point. I'm glad that we dealt with it. This was a question of, do they only go after binary violation? Did you do this? Did you do that? And the answer has been no. We've seen very substantive engagement on complex things, even though my impression is, surfing the internet every day, there would be plenty of binary violations to go after that should be much easier to pursue than the complex stuff. But let's talk about what it actually is substantively. And we have 4 groups here on, and I'll turn to Dominique on the very first one of notice and financial incentive and get her impression of what exactly the Attorney General is looking for, what companies have been doing, what kind of answers have been giving, and I'll have a series of questions on that. And then want to also talk about the 3 other topics: do not sell, access, deletion rights, and disclosures. But let's start with notice of financial incentive and what you've been seeing, what the requests are. For those of you on the audience to say, I don't even know what that is, we want to really focus on the enforcement today. So there are CCPA 1.0 section, and there's quite a few of you have actually written for your law firms on that. We want to now hear, Dominic, how exactly are the representatives of the California Attorney General focusing on these, and what cases do they say you should have had one, and what kind of questions do they ask?
Yeah, so if there is a offer or some kind of exchange of personal information for which there is going to be some kind of price offering, price cutting, quality service difference, then that is when again, looking at where we have seen discussions, that is where the AG's office and the statute just all kind of tie together in 1798.125 and in the regs 999.307. That is where they want to see a notice of financial incentive. You guys all know what the notice of financial incentive needs to include. Some of the stumbling blocks for companies, frankly, have been on valuing data. It's not something we typically do in companies. Data is an intangible asset. It doesn't appear on a balance sheet. So clients have had to go to that exercise of valuing their data very quickly. And there are resources out there to help, but that is that's the thrust of it, Lothar.
So the really focus is on this value. It is probably could be found by accountants somewhere on balance sheets, but companies haven't posted something to consumer and told them, especially, what is your data worth to us? And how do you go about companies now within a 30-day, or maybe by the time you get involved, 27-day cure period, to come up with numbers for this? And do you come up with a number? Is it a dollar amount, or is it more like a formula?
Both. So it's a process. So first of all, on the balance sheet, an intangible asset will get appear only in an M&A context, and lots of times the data is not pulled out. It's just an intangible asset. I've seen a few 10Ks where you've actually seen data valued, but it's tough. And I think the other piece of this is that data valuation, even though there's guidelines in the regs on how to do it, is fundamentally something that's going to involve valuation experts. So getting connected with the right people within the enterprise, and it's usually nobody here on this screen has a data valuation expertise. Most of the valuation experts don't themselves, but usually there's someone in the company who's been valuing assets on the M&A side that you can liaise with. And we, through our firm, retain an outside expert that helps us liaise with that point person. And yes, there is a process for that. And a lot of those, some of the experts or the experts that we've worked with have written a chapter in my book, implementing the CCPA, that's on the IAPP website. And so that's what we have done. I know some clients have done it on their own. They put numbers together with their, very sophisticated CFO and valuation experts, and they've had to crunch and do it. I would really recommend that companies do this not under, you talked about 27 days, sometimes, with the deadline and stuff, you're talking 14 days, trying to pull all the people in the company that touch data that know about overhead, cost of the business. I mean, it depends if you're using the cost approach. Anyway, there's a methodology that really, as lawyers, this is one of those things where I found it helpful to team up with actual valuation experts, because I don't think it, for me personally, I didn't think it would be doing the client justice for the lawyers to try to legalize their way through it. It's for those regs, just really getting an expert who can help put that together. And then what you put out into your notice, I've seen varying things. I have seen very down to a dollar amount, and that seems to be a growing trend since the public announcements that were recently made by AG Bonta. In addition to what happened in July, I've now seen a trend of actually putting the dollar value in the notice. In the past, there's also been the calculation and value, like basically the method for how the data is being valued has been accepted. So I think really right now, from a peer standpoint, you're going to see a lot more people now that these enforcements have happened, putting dollar
All right.
amounts.
Thank you so much, Dominic. I see that David and Jevon have their hand up. I do also want to get to do not sell data access requests and other things, but real quick, David, did you want to supplement here, or was that a leftover?
It was a leftover, but I will do a quick supplement as long as my hand was up. You know, what I'd say is I think this is one of those situations where people, society, the privacy community would do well to step back and look at what we're trying to advance from a policy consideration. As Dominic said, and I would echo it, most companies do not naturally value this type of data. It's an unnatural exercise. It's a forced exercise. And I don't know that this is what the CCPA was intended to force companies to do. And if you go back to that initial Berkeley consulting group impact, or the financial impact that the statute was going to have, they didn't assign anything, I don't think, to any type of activity that every company that has a loyalty program or every company that has an opt-in would have to go through a financial accounting exercise. And
all right, David, we'll have to cut you off here because we just want to be focused on enforcement. Maybe Alysa or Jevon have something to share on what the Attorney General accepts here for these notices. I totally agree with you, David. That's but I want to get to the position of the Attorney General. I don't know, Alysa, do you have something to supplement?
Sure. So I think we might go with that premise that we're seeing a varied approach in these investigations. So I've not seen a trend requiring, at least in the matters that I've held, with a dollar value disclosed. So there's some variation there. But I will say, and this goes to one of the questions, some companies offer a loyalty program. They may offer a coupon to sign up to get a newsletter. They may offer multiple different kinds of loyalty programs. And so really thinking holistically about what are the different types of offerings the company has, because my experience, the AG's office is very interested in that full scale applicability, and really got into the details and questions on what data do you collect? How do you link it with other data? What are you using this data for? Are you using this data for any ad tech related reasons, for any sale, other kinds of sale reasons? So really understanding all of the nexus points here before you evaluate what does your notice of financial incentive disclosure look like. And that ultimately was a link. It's a link at the point of where somebody is going to participate in that loyalty program or notice of financial incentive. It's not necessarily a checkbox, but it's a clear experience where the consumer sees that notice and is able to submit information if they want to participate.
Thank you so much, Alysa. I'll turn now to Jevon and ask you to give you a supplement on notice of financial incentive, but then move us forward to do not sell and what is critical there.
Yeah, that sounds good. So real quickly on the No-5, Notice of Financial Incentive, I think a lot of our clients struggled first with the question of should a No-5 be added, right? So is the Notice of Financial Incentive required? I think that's really the material question. And I think that's where most of the clients would have started by saying, we don't think it's required, and then get the letter, Notice of Violation, and be surprised that the California AG thinks that there is a violation. Two questions most of the times come up from a client's perspective. One is we don't sell, or two, we don't discriminate. We don't sell data. We don't make money from selling the data. And two, we don't discriminate. So why do we have to do a notice of financial incentive? So we work, I want to say that's kind of really the back end conversation that happens. And that needs to happen quite quickly because you can't wait 30 days to figure out whether you're going to post the no-fi or not. You know, to Dominic's point, it's going to take a significant amount of time to figure out what methodology you're going to use to value the data. And so the question of, yes, we will comply and we're going to put together a no-fi and we'll post it, or no, we're not going to. And we think this is not, something that we believe is not a violation. I think that's the first question that the company needs to address. and then take a look at what is required in the no-fi, which is, what and all of the panelists have talked about. But I want to say that the clients oftentimes struggle with that first question of why is a no-fi required? And so, happy to.
And have you been able to convince the AG's office that it wasn't required and they backed off?
Good question. No. That's a simple answer.
Let's talk about do not sell.
Have you had any instances where the AG has agreed with the client?
I see shaking hands here,
no.
I think.
No.
Let's get to do not sell, though.
Yeah.
Jivan, tell us a little bit of what the focus is. That was really the new attraction of CCPA for everyone, this notice of financial incentive. I didn't even see that as one of the top 10 worst things in this law. So it's interesting that this takes our first action item here, but let's get to the second one, do not sell. That was the main thrust of the law. And what is the AG focus?
That's exactly right. So I think the reason that we started with the notice of financial incentive is probably because it's the one area that's taking our clients by surprise the most. Largely because of the round of the letters that went out. The AG announced that there was a round of investigations going out. Before that, I would have said the opt-out was probably the biggest issue that most of our clients were, again, surprised to get notice of violations. So you asked earlier, Lothar, are these binary, kind of, easy, yes or no, or are these more complex? I would say that both for the notice of financial incentive and for the opt-out, it seems binary, but if you look under the hood, it's very complex, right? The question starts with, do you have a notice of financial incentive on your website, and should you? And for the question for do not sell is, should you have a do not sell button on your homepage, and do you? And so it seems binary at first, but I think, whether the company agrees with the AG and decides to comply with the law or not, and decide to fight it and prepare a written response, why they think that AG is not AG's position in terms of the alleged violations is not correct. I think that really is a complex exercise. As I said, we have not so far, seen. We have seen, I would say, rather, a number of companies that are engaged with the conversations with the AG on the interpretation of whether the do not sell must be added to the homepage. And the questions that we have received start with the do not sell link on the homepage, but we have also gotten questions on the GPC as well. So the AG is looking for companies to comply with GPC signals.
When we prepared, we found that the AG goes pretty deep on this stuff and actually asks companies to show their processing contracts and say, well, this is not good enough. It doesn't have all the different elements of what a service provider agreement should have, or this way of working with ad tech is not acceptable, is something that we've heard when we prepared for this presentation here. Other points, Jivan, that have been really on details where the spotlight is on and clients should think about cleaning up or preparing their positions more robust?
Yeah, I would say, I think you showed earlier during the slide, the case examples that were published by the California AG in July last year. I think they are really helpful. If any of you, and I'll try to add it in the chat, if you have not looked at that, please take a look at it because it is published by the California AG. Some of the case examples are right on point. It will tell you the kinds of case examples of industries and also the kinds of violations that the AG has worked on and the remediations that the companies have done. You'll see there, I think there is at least half a dozen examples that were related to opt-out and the do not sell. The focus that we have seen has been related to behavior advertising. So to the extent that you are using third parties to do behavior advertising and yet you don't have a do not sell link, we have received violation letters from the AG.
Alysa, I'll call on you for a little follow-up here, because when we prepared for this, we're also asking, do we only see business to consumer? And you've seen also business to business with some consumer data in the mix. And I think all of the panelists had seen some cases of that. I wonder if you would supplement your experience there on do not sell and then move us along with access requests and what you've been seeing there.
Sure. So I actually have not directly handled the B2B, but had heard from a direct colleague who is handling it. B2B, direct B2B business, but their ad tech marketing was what flagged an inquiry. And just to maybe follow up on what Jivan was saying, It goes into every single tag that you might have on your site, and also what are other ways that you may engage in ad tech that could be a sale, including use of identifiers. So it really has required an upskill of a lot of privacy lawyers to learn ad tech fairly intensely, so that they can be able to understand the business practices and advise on compliance and operationally with do not sell. On access and deletion, what I have seen is the AG's office wanting to clearly understand both the timing. So you cannot satisfy an access request by deleting instead. That from a sequence point, if you get both of those requests at the same time, then you need to handle the access request and then handle the deletion request. But if there is that kind of inquiry, what we saw, the AG's office really wanted to know what the whole process was. So how did the company ensure that requests that came into the company were handled appropriately? And that goes into policies and training, as well as the template response. How is the company responding? Monitoring complaints, perhaps, that on social media and other areas that really speak to how the company is responding to access and deletion requests. And then I did handle one for an exempt company, so financial institution company, and they had to answer that on why they didn't comply with an access request. And there was a partial, this is covered by GLBA, but as to this, as to the ad tech side, here's how the consumer can opt out. So that was, at least in that circumstance, that was accepted.
And was your sense that these came out of complaints? Consumers didn't get their access requests answered, or were these more policy initiatives?
It's hard to say. I think in one of them, the AG's office was pretty clear. They had seen some complaints on social media. So we know that was tagged by it. I think more of the do not sell ones, which can also have some access requests, seem to be from the AG's office doing their own checking on compliance on company sites.
Very good. One more topic, David, disclosures. Companies that don't even put the privacy notices up there, or the privacy notice doesn't tick all the different boxes in CCPA, highly complicated, all these cross-references. It's been hard to work with clients, and I've really told them, let's have a totally separate privacy notice that just addresses CCPA. Definitely for foreign companies, you can't comply with CCPA, GDPR all in one document and then say this is still understandable. You'll miss the concise and understandable functions. But there are also companies where they probably didn't even try to address all those different points. And what is your sense on the disclosures? Some key questions here also from the Q&A session. Do you have to do the ad collection notice separately, or if you're online, do you just send everybody always to your 15-page comprehensive annual privacy notice? And have you seen cases where there was just nothing at all and the companies had to place forward? I think the AG is very careful after the Delta fiasco a few years ago, when the Airline Deregulation Act was found out to be trumping California state law. So they're taking a closer look at this. And what has been your experience, David, on these? And
that's a lot of questions built into one. So let me start with this. Lothar, I think you flagged before, are these going for complex violations, or are they going for the easy binary violation? And binary violation, for those who are listening to the program, I think all of us understand to be, you didn't even try. You didn't try to put up a privacy notice. You didn't try to give access rights. You didn't try to get deletion rights, stuff that really is not a legal debate about. My experience, which again is limited, has been they have not gone after the binaries. They've gone after the more complex stuff. And there are a lot of companies out there which still don't have compliant privacy notices, which still don't get access rights, which still don't even reference deletion rights. And I have not seen too much in terms of, just from what I've heard, none of my clients are in that boat, by the way. All my clients have perfect privacy notices. But the disclosure issues that I've seen have been more nuanced. A lot of them have dealt with offline disclosures, things like secret shopping in stores, and the AG's office going in and going to a register and not seeing a notice of collection or a reference to the privacy notice, and then raising those issues, and then getting into the, it was there, but did they not see it, or was it not big enough, or was the font different? Those kind of vary, and I would put that on the complex side. That's not a binary. That's not you didn't have a privacy notice. That's well, the reg didn't say how big it has to be, or what color it has to be, or where it should be positioned, and the company thought it did in good faith. That's more of what I've seen in the area of disclosures. If there are a lot of violations that are being happened, or notices of violation being pursued on more binary issues, They may be out there. I think they may just not be percolating up to our firm or some of the other firms that we talk to.
And David, would you, when you resolve these with the Attorney General's office and they're saying, hey, you should be disclosing this or that thing additionally, even if you don't agree with it, it's probably easier just to throw it in there and make the policy a little longer. It doesn't harm the client that long, probably saves them some money, and California Attorney General is happy.
I don't think I've had
happy Attorney General, happy client.
Of course, yeah. My view, and I don't think I've had a situation, I have to think about it. I don't think I've had a situation where the Attorney General's office has felt like the privacy notice didn't contain the right quantity of disclosures. But to your point, Lothar, if it's an issue about terminology, and I can think of at least one situation where they said, hey, this would be better worded this way than that. I don't think any company wants to fight that. I mean, I think companies in good faith try to draft it in a way that consumers would understand it. And if the AG disagrees, I think most companies are motivated to find a solution that the AG would agree with, and make the modification move on. That is relatively low cost. It can be a little bit higher cost when you're talking about in-store notices, replacing billboards and replacing signage, but even that can be usually handled pretty easily.
No, thank you so much, David. We have a few minutes left. One question I wanted to point out there is, what about other California privacy laws? So we're talking about CCPA. That is one of literally hundreds of different laws. Siobhan, while we're on the subject, does the California Attorney General also throw in some other things, or is it all topic of the day, the new shiny thing that everybody focuses on, and we can prepare for very targeted enforcement on this new exciting law, and we can forget about the hundreds of other laws that are out there?
So I think we talked about it while we were preparing. I think many of us have worked with clients with the California AG and with other AG that are not just focused on the CCPA. So clearly, the privacy unit is not just enforcing the CCPA. We know that there are active privacy and other consumer protection investigations that are ongoing that are outside of CCPA. In my experience, the CCPA investigations and the non-compliance letters that we have received have focused on the CCPA, although we have seen some bleed into other federal laws like GLIBA or HIPAA. So to the extent that we have a financial service institution, or if there is a health data involved, we would talk about the intersection between those federal law exemptions and CCPA, but we have not seen a notice of violation for CCPA that combines it with other, federal or state laws. In terms of our experience, I think it looks like we're a couple of minutes left in the session. I think we also want to highlight that obviously this is just 5 of us, 5 practitioners that are talking about our experiences, and obviously the cases that we see are the ones that are floating up to outside counsel. So clearly there are many other investigations that are being handled at the in-house level that are not going to come to the in-house, that come to outside counsel, and specifically to the 5 of us. So I want to make sure that that is clear, that we are just representing our own personal experiences with the California AG.
Thank you so much, Siobhan. I see Dominic has her hand up, and I will call her in here for 1 second, but I want to also underline what you just said, and it's so wonderful that you do this work at the California Lawyer Association. And you'll say a few parting words about getting even more to join this crowd. And I want to encourage all of the participants that are signed up for this webinar. We had more than 300 registrations, and this will be available. This is being recorded. And we're also thinking about perhaps writing up some Q&A topic that comes out of here. So please do write to us. And the California Attorney General does not only focus on the CCPA you've just heard, so there are lots of other laws, and sometimes questions are just on privacy laws, I understand. Dominic, one more point, and then I think I'll return the topic to Siobhan to wrap us up today.
Awesome. I just was going to say really quick, I threw into the chat the Implementing the CCPA book that I mentioned. There's an appendix that has a roadmap to complying with CPRA. And second, I wanted to just clarify on the notice of financial incentive, I have not seen the AG's office insist that a dollar amount be in the notice itself. What I wanted to say is I've seen a trend since AG Bonta's announcement just a few months ago about the enforcement on the loyalty, that I have seen as an industry trend, people doing this appear to be on their own, but I wanted to make that distinction.
No, thanks so much, Dominic. And here's the slide deck is available to everyone. It has our contact information. Reach out to any or all of us with additional questions. And Jiwon, say the final words about joining the section.
Yeah, thank you very much. So again, this is a CLA. We are the Bar Association, and I say we because I served as immediate past chair last year. We are representing all privacy lawyers that are licensed in California and others and friends outside, in and outside of California. The reason I say that, and please join the CLA privacy law section, because we do CLA events and webinars and fireside chats like this. And to the extent that event like this was helpful, and if you would like to hear more from the panelists today, or from other, or on topics that are more specific, since this was really kind of focused on the enforcement section, there are other working groups that are being formed. So CPRA, for example, working group is formed to start looking ahead at some of the draft rules that we anticipate from the CPPA, from the Privacy Protection Agency. So if you would like to get ahead, if you would like to be on the mailing list to receive events and news that are specific to California privacy law, I think CLA is a really good resource. So I want to put a plug in again to join the section, and any of the events, including today's recording of the today's event, will be on the event page for CLA privacy law section. Thank the panelists today and Lothar for doing a wonderful job moderating this panel. Our email address and contact information is here. If you have any questions, would like to follow up, have any specific questions, please feel free to reach out to each of us. Thank you very much for spending an hour with us, and look forward to seeing you at the next CLA event.
Thank you all.